Hi, I'd like to welcome everyone that's watching. Over the last 25 days, I've been documenting a series called Justice for Stellenbosch Arts and Craft Market. If you're familiar with the series, you know that a legal protest was held recently, and the Stellenbosch municipality had a representative receive the petition signed by members of the public in favor of the traders to remain in the town square. I feel it necessary to move on to the actual legislation and law that pertain to such events. I would just like to make it clear that I'm not a lawyer and I've never studied law, and this will be the first time that I'll be delving deeply into South African legislation. I do, however, find it necessary not to shy away from legislative language and feel that it's important to engage it and to try and understand it. So today I'm going to briefly examine legislation that commenced on the 24th of May 1991. It's the Business Act, which I believe is still to be enforced, but I'm not 100% sure. I think during the rest of the series, we're going to start examining how laws are actually put into place, how they get bypassed by things called bylaws, etc., etc. So it's going to be an interesting journey in law, especially for me. But today we're going to look at the legislation that focuses on the regulations relating to street vendors, peddlers and hawkers, which is a part of the Business Act. Now I'm going to read through this document, and I'm probably going to pick out the most pertinent aspects for the video. But I'll ask you to stick with me, see if you can hang in there with me, because we're going to start trying to dissect legislative language. I feel it can be quite deceiving at times, and it doesn't quite get to the point. This particular document, I think, was written in good faith, but at the moment I feel it's just not being stuck to, and whether that's because bylaws have come and made it null and void, I'm not too sure yet. But we're going to go through the document, we're going to check it out, and see what it says. And we're going to try and see if the Stellenbosch municipality is sticking to the legislation, really, the laws that were written. So let's see. Okay, when you look at the document first, you'll see the South African seal. I would assume that's the South African seal. It says Provincial Administration of the Cape of Good Hope, Community Services Branch, Chief Directorate, Local Governments, gives an address, PO Box, 1st of September 1992. It says to all local authorities in the Cape Province, including local authorities established in terms of Acts 102 of 1982, regional service councils, and the Walvis Bay. So it's basically saying to everybody, we're going to say something now. Commencement of the Business Acts 1991, Act 71 of 1991, regulations relating to street vendors, peddlers, and hawkers. And it starts with point 1. Your attention is drawn to the regulations relating to street vendors, peddlers, or hawkers published under Provincial Notice 404, dated 28th August 1992, in terms of the Business Act 1991, Act 71 of 1991. Okay, so it's saying your attention is drawn to that particular act, and it's talking about the Business Act, and it's the part that's relating to street vendors, peddlers, or hawkers. Point 2. As you will notice, the regulations have firstly been drawn up in the spirit of the Business Act 1991, and secondly in accordance with the national policy of economic development, competition, and deregulation. Okay, so there it's saying it's written in the spirit of the Business Act, which I would assume it means the spirit meaning in good spirit, that everyone is allowed to trade, everyone is allowed to set up a business out of their free will and will not be impeded in that. I would assume that's what spirit means. They also promote the principle of informal trading, which has of late come strongly to the fore in South Africa, and plays an important role in creating work opportunities. There, they've said it. Okay, it's come to the fore, informal trading has come to the fore, and it plays an important role in creating work opportunities. Point 3. Successful political change in this country can only be achieved if it is supported by a vibrant economy, capable of providing adequate work opportunities to alleviate the critical unemployment which exists at present. Okay, so there we go, stating the obvious. Point 4. In order to assist this administration with the drafting of the regulations, a working group was appointed during 1991, in which representatives of the Municipal Association of the Cape Province, the Cape Town City Council, the Western Cape Regional Services Council, and the SA Police and the administration served. Okay, so to assist the administration with drafting these regulations, they say a working group was appointed in 1991 to address this, and they've listed the representatives of this working group, which are the Municipal Associations of Cape Province, the Cape Town City Council, the Western Cape Regional Services Council, the SA Police, and the administration itself. Point 5. The draft regulations were published for comment under Provincial Notice 577, dated 2nd of August 1991, and comment from 29 local authorities and institutions such as the Small Business Development Corporation, the Informal Business Forum, and the Law Review Project were received. Okay, so they published a draft of the regulations. It was open to comment, like that's the official procedure. You know, the regulations are opened up for comment, and it says that they got comment from 29 local authorities and institutions. They name them, and so they say that they received comment. Point 6. The proposals and comments were considered by the working group at 4 subsequent meetings, and several amendments and improvements were effected to the draft. Okay, so that point kind of says that the comments that were received, it was an ongoing process. So the working group at 4 subsequent meetings, and several amendments and improvements were effected to the draft, which means the regulations that were put into law had to go through a certain procedure, open up to public comment, regular meetings, working through issues, adding amendments, adding improvements, before the final draft gets made. Point 7. The amended draft was again submitted to the Cape Peninsula Informal Traders Association, the Law Review Project, the Informal Business Forum, and the SA Police, the Small Business Development Corporation, the Municipal Association of the Cape Province, and the Cape Town Chamber of Commerce for further comment. Okay, so the procedure goes further. Anything that's written into legislation needs to be approved by certain bodies, certain people, and at the end of the day, it goes very individual. That's a democracy. So this was done in that procedure, it seems. Point 8. The further comment was discussed by the working group at 2 subsequent meetings, and after final amendments were effected, the product of 6 months' work was finally accepted. Okay, so one more meeting, one more discussion, which is good. And it looks like they say after 6 months, a final document was drafted. Point 9. As the regulations differ from the draft, it was considered necessary to bring Regulation 3A and B, which regulate the promulgation of prohibited areas, specifically to your attention. Okay, so the word promulgation, according to Wikipedia, means, here we go, promulgation is the act of formally proclaiming or declaring a new statutory or administrative law after its enactment. In some jurisdictions, this additional step is necessary before the law can take effect. Okay, so basically the way I understand it is that they're bringing our attention now to points that relate to making a law after the law has been enacted, and specifically to areas that are prohibited for trading. Okay, point 10, regulations 3A and B. Now this might get a bit heavy, but let's try and get through it, and I'll try and comment as I go along. It states, in terms of this regulation, the administrator may declare certain prohibited areas, for example, on a verge contiguous to a certain building, and places commonly used by the public, or to which the public has the right of access, or a category of such places where trading by a street vendor or a peddler or hawker may not take place. All such places must be separately identified and proclaimed by the administrator by notice in the official gazette. Okay, my understanding of that is this, that the administrator or the municipal manager has the right to prohibit areas. And they give examples of those kind of areas, contiguous to certain buildings and places commonly used by the public, or to which the public has the right of access, or a category of such places. Now, that is quite ambiguous because it could pertain to many things, but the way I understand it here is if it's in the way, if it's getting in the way of public access, if it's on a corner where it could inhibit, traffic or pedestrian traffic, that would be a problem. It also says all such places must be separately identified and proclaimed by the administrator by notice in the official gazette. Okay, so any areas that are prohibited to traders needs to be identified and then proclaimed in what would be called the official gazette. Now, the official gazette would be a booklet of sorts that is published in local municipalities stating those local municipality laws. That's the way I understand it. But to get those laws into the gazette, a certain procedure needs to be followed. Okay, here they briefly talk about it. It has to be identified. There should be some sort of debate as to why that this site cannot be used as a trading site. Everyone should be in agreement, and then it should be published. And then it's in law. So anyone trading on that site is essentially now breaking the law. Okay, now think about that for a while. It can't. The municipality can't just say, "Oh no, you must go now." It doesn't work like that. There's a certain procedure that needs to be followed. I think according to the Stellenbosch municipality, this procedure has been followed. Well, it doesn't look like it. It certainly doesn't look like it, because if it had been, we wouldn't be in the situation that we are in now. Okay, it continues. In this connection, I wish to point out that the administrator in executive committee has decided not to proclaim any prohibited areas beforehand in terms of regulation 3A and B. The situation will be left to develop on the ground of experience gained. If local authorities come across instances where hawking in a specific place creates serious problems, and the problem cannot be solved or removed after an effort has been made to find a solution by means of negotiation, application can be made for the declaration of a prohibited area. Such an application must be accompanied by a plan indicating the area, a detailed boundary description, and a full statement of reasons. Okay, so what I'm getting out of that is there must be some sort of accountability for prohibiting an area for trade. Look, sure, you can't just trade anywhere. I can't just set up a stall in the middle of the street. Obviously, I'm going to get in the way. But what it says very clearly here is the situation will be left to develop on the ground of experience gained. Okay, so if there's an open space that can be used as a trading site and there's no real serious issues, let it be used until problems start arising. Then those problems need to be dealt with. Now, in the case of Stellenbosch, we're talking 18 years on site, and suddenly now they're told to move. Okay, it also says that if local authorities come across instances where hawking in a specific place creates serious problems and the problems cannot be solved or removed after an effort has been made to find a solution by means of negotiation, application can be made for the declaration of a prohibited area. Okay, so that's pretty much saying right at the end, when all negotiation has failed and there's serious problems on this site, and I don't know what they would define as serious problems. Serious problems where, people are killing each other? I'm not too sure. I'm not sure what they mean by serious problems. But basically they're saying they have the right to prohibit the area after a series of negotiations have all failed. But it also says, such an application must be accompanied by a plan indicating the area, a detailed boundary description, and a full statement of reasons, which means there's a certain accountability for certain actions that needs to be presented. You cannot just kick people off a space just like that. There's certain procedure that has to be followed. Here it is, stated in the law. It continues. Local authorities may, open brackets, and in specific circumstances they will be encouraged to, close brackets, make standing arrangements with the informal business sector and where the need exists also the formal business sector to form a discussion forum where, by way of consensus, among other things, 1. A code in respect of hawking may be drawn up, and 2. Conflicts can be handled when a dispute about a specific area arises before the administrator is approached for a prohibition. Okay, so that's pretty self-explanatory. It's saying that local authorities are encouraged to negotiate with informal traders, to include the formal businesses around them, to draw up a code in respect to informal traders, to handle issues before it gets to the point where an administrator must now make a site prohibited. So this document is encouraging as much negotiation as possible, because the reality is you're kicking people off their work. You're taking food from off people's tables. That's how heavy this is. That's how important this is. So negotiations need to be worked through before it gets to the point where people are out of work, people or don't have food on their tables. Okay, continues. Several categories of prohibited places were announced for comment under Provincial Notice 65, dated 31st January 1992. Comment varied from total rejection to requests for additional places. Requests for controlled hawking in these places were also received. On account of the very diverse opinions and the impossibility of complying with all requests, it has been decided not to promulgate a final list in this connection beforehand. Okay, so here it says that several categories of prohibited places were announced. So they announced places that were prohibited. They opened it up for comments. They got very varied comments. They couldn't reach decisions. So what they did was they decided not to declare prohibited spaces beforehand, so they would allow spaces to be used, and experience would have been gained on the ground, and they would have had to have worked through the process that they described, and that process would have been the procedures. Okay, it continues. A request was received that the categories of prohibited places should rather be proclaimed controlled areas, where control would be exercised over numbers and which local authorities would have to indicate as such. Unfortunately, this cannot be complied with, as the Business Act 1991 does not provide for it and will first have to be amended. However, there is support for the idea that a measure of control should exist, for example at beaches. The practical application thereof will, however, be extremely difficult. Okay, so here it's kind of saying what a difficult process this is, because there obviously are spaces where, wide open beach and having a whole bunch of vendors, or, there would have to be certain controls, which is fair. Okay, so it's saying that it's open to having some sort of control over local traders or informal traders at certain areas, and it talks about beaches here. But the last line of this paragraph is very interesting. The practical application thereof will, however, be extremely difficult. Yes, because it is. Say now you have a big wide open beach, lots of space, and someone wants to set up a stall. It will get complicated. Okay, it continues. Please also note that the owner or occupier of private land, whether or not it is a prohibited area, has the right to forbid anybody from hawking thereon. Okay, fair enough. There we go. I have a piece of land. Obviously, if it belongs to me, I can say yes or no whether a person can hawk on it, And more than likely, people on their private land are going to say no. Okay, it continues. It must also be borne in mind that any other applicable requirement of an act in regard to, for example, town planning or the safety or health of the public must also be taken into account in the trading of a hawker. Okay, fair enough. So if there's any buildings going up in the town on a certain space, if it talks about the safety or health of the public, if somehow a certain trading site impedes the health or safety of the public, it should also be taken into account. And fair enough, saying our building is going to be built on a certain site in 3 months, it wouldn't make sense to allow traders to work there because, they're going to be out of the space in 3 months. So that's fair enough. Okay, point 11. We're almost done. As previously announced, the standard regulation relating to peddlers and hawkers as promulgated under PN 588 dated 5th October 1950 will be repealed, and every local authority will be expected to repeal its own bylaws in this regard. Only the new set of regulations as promulgated under PN 404 dated 28th August 1992 will from now on be valid. See also paragraph 2 of Circular LGBP 57 dated 17th December 1991 in this connection. Okay, so all it's saying is that it's repealing laws that were put into place in 1950, and it's saying that all local municipalities need to repeal their bylaws, and only the new set of regulations should be used. Okay, point 12. For your convenience, I list the circulars which have appeared in connection with the Business Act 1991. Here's the list. Number LGBP 22 dated 19th June 1991. Number LGBP 41 dated 5th September 1991. Number LGBP 49 dated 8th November 1991. Number LGBP 57 dated 17th December 1991. Okay, so a whole bunch of legislative stuff there. Okay, final point, 13. Any inquiries relating to any aspects of the Business Act 1991 or the regulations may be directed to a Mr. H. Lezerberg, and he states a telephone number. And it's signed by the Deputy Director General of Community Services. It has a PS. It says Circular LGBP 23/1992, which is this one, was sent to all local authorities and regional services councils in the Cape Province and Walvis Bay, excluding local authorities established in terms of Act 102 of 1982. Okay, so I'm not familiar with any of that. But there we go. We have the law regarding informal traders, which is stated in the Business Act, which basically, just to summarize, means areas that are prohibited for trading needs to be negotiated first. There's a procedure that needs to follow. You cannot just tell people that have been working on a site for 18 years that they now suddenly need to move and they must go. I know the municipality has spoken about some sort of negotiations happening since 2010, but clearly the situation has got to a point where it's clear that certain procedures have not been followed correctly, and it's now got to a point where it needs to be faced.